Support from the show comes from Hemmat Law and Quimby Bar Prep. Whether you need kick-ass attorneys or want to join a team of your own, please go to hemmatlaw.com. And big thank you to Quimby for sponsoring the rest of our segments. Whether you need CLEs, bar prep, MPRE prep, they've got you covered. Go to quimby.com. Lindsey, how are you doing today?
I'm doing great. We just came off of office hours, which to you folks at home will not come out for another couple of days. So go listen to that episode and see why I'm happy when it comes out. But for today, we've got a whole different story to dive into. I'm really excited about this one.
Lindsey, tell the people about what we're talking about today.
Oh, man. So very recently, I think, what day was it? It was on March 17th.
Yeah.
The HR company Rippling filed a crazy lawsuit against the other HR company Deel for corporate espionage.
Yes.
So that's what we're diving into today.
So I think a good place to start is, it's more specifically, this was filed in United States District Court for the Northern District of California, specifically the San Francisco Division. And I think the second best place to start is to say, who are these people? So as Lindsey referenced, Rippling was founded in 2016, is not just an HR company, but it's like an HR technology company.
Yeah, they do they'll do all of the onboarding and all the payroll. They'll take care of all of your HR operations for you.
They do things like workforce management, time and attendance, automated time tracking, scheduling, talent, recruiting, managing employee data, compensation bands, ASO compliance, HRIS. They'll do all sorts of things.
The whole schmagoigle.
Yes, the whole schmagoigle, truly friend of the podcast of schmagoigles. And then Deel, which is another AI HR technology company who was founded in 2019 after Rippling, basically does the same thing. They're pretty much direct competitors.
Yes.
They have some unique product overlaps, and they're not a direct one-to-one clone, but they're often in the same spheres.
Yes.
And they have competitors across almost all of the spheres that they operate in.
Yeah, it's not just them. There are plenty of other businesses operating in this.
And they sued, and this week, People Center Inc., doing business as Rippling, a Delaware corporation, much like this podcast.
And Deel is too.
Yes, and suing Deel Inc., a Delaware corporation as well. They're probably, actually, chances are they're headquartered on Orange Street, which is the same building that we are. Yeah, so technically we may be legal neighbors. I think a good place, I always like to, when reviewing a complaint, I always like to start at the end. So the attorney who signed this, best I can make out, I'm not familiar with her work specifically, is Kathleen S. Messenger, attorney for Plaintiff, People Center Inc., DBA Rippling. She's with Quinn Emanuel, Urquhart & Sullivan, LLP. A good friend of mine actually used to work for Quinn Emanuel.
Oh, that's awesome.
Yes, and then they're also her, and she's the actual, Kathleen is the California admitted attorney that's taking lead on this.
Gotcha.
She is accompanied by 1, 2, 3, 4, 5. Yeah, that's it. 6 other Quinn Emanuel attorneys who are appearing pro hoc vice. So if you're not familiar with pro hoc vice, it's basically a pass for an attorney to appear in a jurisdiction of which they are not licensed, just for a specific case. You have to ask for leave of court, which, to be fair, is usually granted. And you have to be sponsored by local counsel. In this case, local counsel is Kathleen Messenger, appearing attorney. So that's not unusual for big law firms to do. I've seen the media and some commentators get this wrong. They're like, oh, pro hoc vice appearances, this is the trial of the century. And I'm like, no, this is very normal for large legal teams encompassing multi-jurisdictional matters to do. Basically, it allows Quinn Emanuel to have multiple attorneys from around the country appearing in this one case.
And both of these corporations have global presences.
Yes. In fact, we'll be talking about the Republic of Ireland and why global payroll is based in Ireland.
Oh, will we? I didn't know there were reasons for that.
Yes, there are.
Oh,
exactly.
Interesting. Cool.
So basically, an overview that we'll go into more detail. We're going to start with an overview. The history of the two companies is that Rippling and Deel used to be friends. So Rippling was the initial provider to Deel. So Deel, when they were coming up, remember they were founded like 3 years after Deel, was a former customer. And it actually mentions in this complaint on page 5.
Yeah, I love this inclusion.
Yes, I'm going to talk about this, but this is my favorite place to start. Rippling and Deel actually used to be pretty chummy. Rippling used to be the provider for HR services for Deel themselves before they terminated the relationship in November of 2022. On the 16th of November of 2022, Sarah Hartman reached out on behalf of the Rippling team, and they got a communique, and it basically says the following: "Dear team, congrats on Deel's rapid growth. There's clearly a huge market for global employee management products, and it looks like both Deel and Rippling have discovered that opportunity. This means that, in some cases, we're going after the same customers with similar products, and that has put us in a difficult position around your use of the Rippling platform." Because remember, these companies do very similar things.
Yes.
"And you've surely recognized the only path to success is by building a comprehensive HR and payroll system. We're concerned that your access to our systems will inform your own efforts in this regard and would prefer that we each compete on the merits of our own innovations. To that end, we'd like to terminate our commercial relationship at the end of your current agreement, which expires on February 28, 2023. We don't offer month-to-month extensions on our agreements usually, but this is an unusual case given that you're requesting that you find another provider. If necessary, we can work on a mutually agreeable timeline beyond February."
Perfectly valid.
Yes.
Perfectly reasonable.
This was this could have been far more rude.
Yeah, that could have been like, you're our competitors. We don't want you anymore. Get out.
Yes.
They offered negotiation and they offered some leeway. Perfectly reasonable.
Yes. So that really contrasts with the story we're about to get into.
Yes, it does.
So Rippling's, I'm going to read from the complaint, paragraph 17. "Rippling's termination notice to Deel turned out to be prescient. Today, Rippling and Deel often compete directly against each other for customers looking for global workforce management solutions, a subset of Rippling's product offerings. Terminating the Deel customer relationship was an important step taken by Rippling to protect its confidential information." And this is interesting groundwork laid by Rippling's attorneys. They are basically saying, like, hey, they recognize this. Deel recognize that this is, this is something that we should be concerned about, and so this is how it comes into fruition. So the general background is as follows.
Okay.
Here we go. Let's jump into this.
Background time.
This case exposes, this is an introduction I'm reading directly. I'll be reading a couple pages of the complaint. This provides the most cogent synopsis from Rippling's own attorneys.
Yes, and it's beautifully written,
Yes.
I might add. I loved it.
This case exposes a calculated, an unlawful corporate espionage scheme orchestrated by Deel, a global multi-billion-dollar technology company. In a brazen act of corporate theft, Deel cultivated a spy to systemically steal its competitors' most sensitive business information and trade secrets. This was not an isolated act of misconduct. It was a deliberate attack perpetrated for over 4 months, designed to steal and weaponize critical competitive data, including the competitor's sales leads, sales pipeline, and its entire playbook for pitching prospective clients. These stolen goods appear intended to be deployed across the Deel organization to gain an unfair market advantage, including by, count 1, Deel's sales and marketing functions to target competitors' leads and pipeline. 2, Deel's customer retention function to leverage stolen pricing proposals to lock in customers. 3, Deel's recruiting function to exploit competitors' internal phone directory to attempt to poach key personnel. And 4, Deel's communication and PR functions to combat and distort negative press cycles. Most shockingly, these espionage efforts appear to have been directed by the highest levels of Deel's leadership, including, upon information and belief, Philippe Bouaziz.
I was having fun. Bouaziz. That was my best guess.
Philippe Bouaziz, Deel's board chair, chief financial officer, and the father of the CEO, or those closest to him. First off, Nepo babies. If I see one more Nepo baby in an all-encompassing position of power, I'm going Joker mode. This industrial espionage scheme came to light very recently when Rippling discovered that its competitor Deel had cultivated a spy within Rippling's employee base and commenced an internal investigation. That investigation revealed that Deel spy used Rippling systems to spy on Deel's own customers who were discussing a switch away from Deel.
Yes.
The spy searched the term Deel and Rippling systems on average 23 times a day for over 4 months, which allowed the spy to comprehensively capture every detail of Rippling's sales pipeline competitive with Deel, including proposed pricing details, sales meetings, and conversations between Rippling and prospective customers evaluating a switch. Training materials from Rippling's sales organizations, pitching to prospective leads, and other proprietary trade secrets only in possession of Deel personnel. For example, On just one day, February 21st, 2025, very fresh,
Very fresh.
Deel Spy conducted searches that revealed 728 new companies requesting a demo of Rippling's products, 282 in-depth notes from Rippling's account executives on companies that were new prospects in its sales pipeline, and through information about 26 new deals with existing customers or prospective clients who are evaluating switching to Rippling directly from Deel, and that is just one single day.
And that's just one example of the type of information that was stolen. So how it worked was Rippling operates on Slack.
Yep.
So all of their communication is going on in Slack. And so all the spy had to do was search Slack, and no matter what channel, if it's an employee facing an open channel, they can look and just see whatever the heck is in that channel, and they can just take all that information right from it.
Yes.
So that's how the spy got this information.
And here's how they actually here's how Rippling's team realized something was
Yes.
wrong.
This is wild.
So the spy, which we will discuss in more detail, was located in the Republic of Ireland.
In Dublin.
In Dublin, exactly. And the reason so many global payroll companies have payroll operations located in Dublin when they have global presences is because the Republic of Ireland has some of the most favorable tax laws out of almost any jurisdiction on earth. That's why Apple will do things like Apple Ireland. They'll give all their IP rights to Apple Ireland and then license it back from themselves and then reduce their effective liability in the US by basically doing it's not a magic transfer, it's perfectly legal, but basically by charging themselves huge fees to get those profits to Ireland where they are taxed at a much lower rate.
Wow.
So it does not at all surprise me that this gentleman involved in setting up global payroll systems is located in the Republic of Ireland.
That's new to me. When I first read that, I was, Ireland, okay.
Yeah.
Why?
Dublin's huge. I mean, it's not like it's more of an administrative center than like you won't find most of the people there, but you'll find a lot of IP and proprietary items are housed in Ireland in some way. And Dublin is Ireland's largest city, so
there you
go. Rippling first realized something was wrong when Deel's COO reached out via WhatsApp to Rippling employees at their personal numbers. At least 10 employees got job offers from Deel without substantive interviews. Employees were concerned how they got contacted by Deel and reported the activity to Rippling, and this is what tipped off Rippling's leadership to like what the hell was going on here. And so they investigated.
I would like to jump in here.
Oh yeah, go ahead. Yeah.
I've got a different story on how it started.
Oh, go ahead.
Well, and maybe this was from the articles that I read. John focused heavily on the complaint.
Yep.
I skimmed the complaint and I read public-facing articles about
go
this.
ahead.
What I found is that Rippling and Deel were both accusing each other of breaking Russian sanctions. And a particular journalist reached out to Rippling's leadership and said, hey, by the way, I'm researching Deel violating these Russia sanctions, and I've come to understand that Rippling might also be doing this, and so I'm going to start investigating Rippling for violating U.S. sanctions too. And then with that email, the journalist included screenshots of internal Rippling messages.
Yes.
That's what I saw as the very first instance of where Rippling realized, oh shit, someone's leaking.
That was right after their employees started.
Oh, okay. This was right. Okay, gotcha.
Yeah, so it was all right around the same time.
Gotcha.
The very next thing they noticed was that, like, hey, journalists are getting internal information is leaking externally, and they're manipulating press cycles, which is what they referenced.
Okay.
But the very first thing was that their employees started getting targeted first.
So that one was really just wild to me, the employee targeting. I didn't realize that came first.
And they were reaching out just by WhatsApp?
Yeah.
Like
just
on their
texting.
personal numbers?
Oh my gosh.
You got to be more subtle than that.
There's screenshots of these WhatsApp conversations in the complaint.
And so Rippling, for whatever reason, Rippling investigated. Paragraph 81 of the complaint reads, the profile logs that capture when a Rippling employee is viewing a particular employee profile on the Rippling HR platform line up with Deel's attempted poaching activities described above, which is to say, texting people. Once again, Rippling investigated DS. Oh, so DS in the complaint is Deel Spy, which is so funny. That's
Deel
very
Spy,
that they call it Deel Spy.
And those are not his actual initials.
yeah, they're not. So like sometimes you'll conceal full names when it's like matters of significant privacy or with minors. So like sexual assault cases, sometimes matters of national security. Here it's just Deel spy, which is very funny. We could talk about him later. He's been named since this complaint came out. Anyways, Rippling investigated DS's activity around the time Rippling employees were contacted by Deel representatives, and once again, Rippling learned that DS had accessed and viewed the profiles of several Rippling employees who were contacted by Deel. Which is odd because, as we talked about, he's a global payroll manager in Dublin. No reason to be looking at any of these Slack channels, to be looking at any of these employee profiles. He's just in global payroll setup. So he's not an actual HR person for Rippling. He's just a guy that like sets up new payroll systems in every country that Deel operates in. So that's what they mean by global payroll. It's not like a payroll guy who runs payroll.
Right. And the complaint specifically outlines how before, let's see, it was November 2024. Before November 2024, that particular employee never searched any of these operations or Deel. He never searched for Deel. And then starting in November 2024, boom, his searches for Deel go from 0 to 23 per day on average.
And then I'm going to continue reading from the complaint because it's prescient. Rippling's search revealed that the alleged spy searched for and downloaded customer-related data often focused on reference of Deel as a competitor, like Control F Deel, like they were just looking for random keywords, including 1,300 instances from Slack channels and 31-page competitive strategy documents that Deel had prepared, discussing Rippling and like counterposing how they're going to beat Rippling. Notably, the spy didn't download any of the 80 other competitors' strategy documents, only Deel's. So they weren't like, which is, I'm just continuously blown away how crude this spy work is, because like there's zero plausible deniability because of how direct and like how straight and simple. Like he was just control effing through Slack looking for mentions of Deel. And
it's really clear.
I feel like there's got to be a more subtle, smarter way to do this.
There's got to be, right? I think it would be easy. I assume for some folks it's really easy to forget just how much information your employer has on your work computer and your activities going on in your work computer. So FYI, if you work on Slack for your employer, they can tell when you search and what you viewed when you searched.
It's true. The computers we have, they don't have any, like these computers that I'm holding up, the black laptops that you see here are property of the Hemmat Law Group and Hemmat Interactive. They don't have any spyware, but even so, they have diagnostic tools that will tell us things like, you know, is the computer on? Is the computer off? What's its network traffic on average? How much of its CPU is it using? And while we're not directly looking and spying on people, if we had to, we could go back and piece together an enormous amount of information about what our teammates have done on our computers.
And so that's part of my guess. I think that this individual was just unaware of how much information he was betraying, but who knows? Maybe that'll come out. So
now we get to the fun part.
Ooh, yes.
So the way they confirmed, so they had suspicions. There were journalists who were getting information, internal keywords that they shouldn't have. Their employees were being solicited in ways, key employees were getting solicited in ways they shouldn't have. But so like Rippling needed to confirm what was going on here. The evening of March 3rd, 2025, Rippling's general counsel sent a letter to 3 individuals. One, Felipe Buaziz, again, kind of really got that, Deel's board chair, chief financial officer, general counsel, and father of Deel's CEO. That's so funny.
And he's the CFO, right?
He's the CFO, general counsel, and father of Deel's CEO. Basically, it's a family. I'm going Joker mode. 2, Spiros Komis, Deel's head of U.S. legal, and 3, an employment attorney at Deel's outside law firm. So outside counsel. Rippling's letter, basically they sent a letter to all of the attorneys that represented Deel. Basically, Rippling's letter included a screenshot of a Slack message of its chief revenue officer, Matt Plank, referencing a D-defectors Slack channel, along with 3 points, which were all believed to be true but redacted for dramatic effect. The screenshot and reference to D-defectors was intended to indicate that Deel had a Slack channel for ex-Deel employees now employed at Rippling, where they shared embarrassing information about Deel, and that the channel contained information which would cause negative press attention if revealed. So basically, they, in a ruse of good faith, they reached out to Deel and were like, hey, we have bad information about you. We want to alert you to this situation. We're not doing anything specific, but they just alerted Deel's leadership. But they reasoned that if there was one thing that was likely to activate their spy, it was likelihood of negative press, which he had been activated for before. In truth, the renamed D Defectors channel did not exist until March 3rd, 2025, or early morning March 4th, 2025 Irish time. Rather than being a gathering place for ex-Deel employees, the channel was set up as part of a ruse designed to confirm that Deel was instructing DS to search for specific information in Rippling's Slack system.
So it was a bait.
It was bait. There was nothing in the channel. There never was. It didn't even exist prior. And that's how they also knew that there was no other way he would know about it, because the channel had no one in it. It didn't exist for any reason previously. And they basically set it up and then only told Deel's leadership about it. And then the fact that this guy fucking beelined right for it means that, again, not very sophisticated spy work, because if I were him... like
you wouldn't go immediately look at it.
Yes.
So the email was sent to the 3 highest people, and only those 3 folks and the leadership in Rippling.
Yes.
Those are the only people in the world who know about this. And let's see here. Within a few hours of sending that letter, the spy opened Slack and searched for the Defectors channel. Within a few hours. That's so damning.
A channel that existed only as bait for Deel and as one with DS could not have known about existed. Absent a connection between himself and Deel leadership, DS ran a slew of targeted searches in Slack. And so I'm just blown away by, like, this is so not worth it.
Yeah, right? It's so not worth it. It's so risky. You're breaking laws in a frankly very obvious way.
Yes, and this isn't just illegal in the United States, though. I can only opine on what will happen in the US if you do this.
Sure.
So the Deel and Rippling, this whole situation's kind of gone off the rails. Rippling realized they chances are they had a spy on their hands. And so they said, here's what we'll do. We're going to confront the spy because he's an employee of ours.
Yes, this is crazy.
In our Dublin office. But they were worried about if they confronted him and sort of the jig was up, they would have hit Deel, and the spy would have immediately worked to
delete all evidence
of the conspiracy. Exactly. So they went to the High Court in Dublin, and here I'm going to read a little bit as possible. Accordingly, last Wednesday, March 12th, Rippling diligently sought and obtained an extraordinary form of relief, an order from the High Court of Ireland directing seizure and inspection of DS's phone. The court order, this is the Irish court order, the court order required that DS surrender his cell phone to an independent solicitor for preservation, pending an adversarial hearing to determine whether Rippling would be entitled to access the data on the phone. So what happened was the court basically appointed a third party to retrieve the phone by order of, under penalty of law, not to look through the phone, but just to hold it for evidence until a full proper hearing can be held, and to decide whether or not Rippling was entitled to go through it. The court order also included a penal endorsement, which typically all but assures compliance, as the penalty of noncompliance could lead to imprisonment. So, by the way, a solicitor is basically it's a class of lawyer in the British and Irish system. In case anyone was wondering what that means, a lawyer. They sent a guy. Served with the court order at Rippling's Dublin office, DS initially feigned compliance before hiding in the bathroom and then fleeing the scene. The independent solicitor informed DS through the door that he was an independent officer of the court.
The whole understanding.
And did not work on behalf of Rippling, that DS was required to surrender his phone for forensic imaging pursuant to a court order, and that he had another phone available to DS to call a solicitor before imaging would take place. So he's basically like, look, just hand over the phone. We have another phone for you to call to contact an attorney. I don't work for Rippling. I just need you to hand over your phone.
And
as he was hiding in the bathroom. Independent solicitor also informed DS that the court order had been obtained due to concerns regarding the taking of Rippling confidential information to third parties. Subsequent communications made clear that the concern involved Deel.
So now the spy knows he's been caught, and he is trying his best to evade.
So this dipshit initially told the independent solicitor, presumably through the door of the bathroom, that his cell phone was in a bag on another floor. The solicitor offered to have an associate retrieve the bag, but DS insisted that he retrieve it himself.
Oh, don't worry, I'll get it.
The solicitor informed trust me, bro, DS that if he was lying, he would be breaching the court order. The solicitor accompanied DS downstairs and took possession of the bag, but in fact, DS had lied. The bag only contained a notebook.
Surprise, surprise!
It held no mobile device, and information and belief DS's cell phone was on his person the entire time. By the way, the phrase "on information and belief," it just means to the best of our knowledge.
Sure.
Yeah.
So, a well-informed assumption.
Yes. After misdirecting the independent solicitor, DS then went to the bathroom, again, locking the door behind him and refusing to come out despite the independent solicitor's repeated warnings the actions were in violation of the court order. Rather than comply, DS was heard doing something on his phone by the independent solicitor, who also heard DS flush the toilet, suggesting that DS may have attempted to flush his phone down the toilet rather than provide it for inspection. But later that day, Rippling had the plumbing of its Dublin offices inspected, but did not locate any mobile device. While in the bathroom and continuing after leaving the bathroom, DS was again told repeatedly that he was required to provide the device or we'd be in violation of court order. After DS left the bathroom, he was informed that taking another step forward rather than handing over the phone immediately would be an additional breach of the order. DS then replied, "I'm willing to take that risk." He then stormed out of the office and fled the scene.
Oh, boy.
Yeah.
The specific stating of "I am willing to take that risk" is just so batshit dipshit to me.
Well, he the fact that he was willing to basically go to jail.
Yeah, for Deel.
Well, I mean, there may be some like
there may
analysis
be
here, because like if what he's done is so much worse than contempt of court, then going to jail for 2 months for contempt of court, the way he sees it, would probably be better than going to jail for whatever he actually did.
Yes.
But what doesn't make any sense here is that forensic. When you send anything on a mobile device, even if you destroy the mobile device, the mobile carrier has records of everything you've done.
Yeah, it doesn't live on the device.
Yes.
It lives in the internet, which is inaccessible and
whether
from
it was
your
on
device.
whether it was on Slack or WhatsApp
or just emails, your private emails.
Yeah, anything that can be retrieved later. I mean, maybe it'll slow them down, but this was useless. This was, I think, discovery will be damning here.
Yeah, this was a clear. We're on the right track. This guy has done something wrong. Of course, all this is alleged at this point, but we know for a fact that the spy ran when a court order was presented in front of him.
And this sort of brings us to what makes this lawsuit so unusual. It's not unusual for competitors to sue one another.
Of course.
Because we hate each other because we're competitors. But the first cause of action in this matter is a RICO action of 18 U.S.C. 1962C, page 37 of the complaint. This is highly unusual. I rarely ever see private. So first, sorry, let me back up. Let me explain what the Racketeering Influence and Corrupt Organization Act is.
Yeah, I've only got a basic understanding, so I'm looking forward to hearing
It's
this.
a federal statute enacted in 1970 to combat organized crime by allowing prosecution and civil penalties, which is how they're suing here, for racketeering activities within criminal enterprise or in furtherance of a criminal conspiracy. So the U.S. legal system was suffering from this problem where mob bosses or people like them, they could prove individual actions for individual crimes, but because it was so difficult to nail these guys to the wall, they'd keep walking out of jail after like a month or two and walking right back into power in their criminal enterprise. So they invented RICO, which there are lots of now state RICO laws that operate similarly. But very basically, to successfully prosecute a case under RICO, the government must, for criminal prosecution, the government must generally prove that an enterprise exists. This can be an individual, partnership, corporation, association, or other legal entity, a group of involved individuals associated in a specific goal. And B, a pattern of racketeering activity. This involves committing at least 2 or more racketeering acts within a 10-year period.
That's a huge span of time.
And RICO also permits a private individual's damaged in his business or property by a racketeer to file a civil suit, which is what Rippling is doing here. The plaintiff must prove the existence of an enterprise. The defendants are not the enterprise. In other words, the defendants and the enterprise are not one and the same. Both the criminal and the civil components allow the recovery of treble damages. And a civil RICO action can be filed in state or in federal court. So what treble damages are just means 3x.
Oh.
It's a 300% modifier. Double or treble damages, you'll see, basically it allows private citizens, anytime they've been victim of a conspiracy, to basically go, give us 3 times what you damaged us for.
Wow.
And this is why they're going after them for RICO, because it has powerful multipliers.
I see. and the breadth of the data that they accuse the spy of stealing is massive. They could really claim so much money over this. I saw one specific instance where I can't remember, the company wasn't named, but it was clear that Rippling was in conversation with this company.
Yep.
And it was documented that very shortly after, the spy looked at that company and Rippling's conversation with the company, and then realizing that that company was in conversations with Deel also, and then later that same day, the company responded to Rippling and said, "Oh, well, we went with Deel anyways."
Yeah.
And, we know that the spy accessed that information, and so yes, they have so much they could claim here in damages.
So RICO is broad and can be applied to a wide range of criminal activities, including murder, kidnapping, gambling, arson, robbery, extortion, but also racketeering and basically corporate espionage here. The power of RICO lies in its conspiracy provisions based on enterprise rationale that allows tying together apparently unrelated crimes with a common objective. So that's what makes RICO powerful. It's like you can have lots of individual crimes that you can prove, but it allows you to tie crimes together to a higher or further goal.
Cool.
And that's basically what's happening here. On multiple occasions, defendant Deel Inc. and others known and unknown, including but not limited to DS and Does 1 through 100, I'll explain what that means, participated in the affairs of the enterprise by engaging in acts of wire fraud and conspiracy to commit wire fraud to further the enterprise's objectives. So we see Rippling's lawyers laying the groundwork here for a RICO charge. Specifically, in multiple instances, Deel conspired to defend and defraud Rippling by working with DS to misappropriate Rippling's confidential business information, using wires in interstate and foreign commerce in violation of the duties of loyalty, trust, and confidence that DS owed Rippling in violation of 18 U.S.C. 1343 and 1349. Yeah. So basically, this is the biggest boogeyman that Deel's lawyers have to deal with. And they're coming after them for the whole sheboygle. So paragraph 117 of the complaint says, specifically on multiple occasions with intent to convert trade secrets that were related to products and services used in or intended for use in interstate or foreign commerce to their own economic benefit, and intending and knowing that the offense would injure Rippling, defendant Deel, and others known and unknown, including but not limited to DS and Does 1 through 100, including agents and employees of Deel, knowingly, 1, that was a doozy of a paragraph.
Indeed.
Lots of commas. 1, stole, with or without authorization, appropriated, took, carried away, or concealed, and by fraud, artifice, and deception, obtained such information. 2, without authorization, copied, duplicated, sketched, drew, photographed, downloaded, uploaded, blah, 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 replicated, transmitted, delivered, sent, mailed, communicated, and conveyed such information. And 3, received, bought, possessed such information, knowing that same to have been stolen and appropriated.
Wow. Beautifully laid out.
And basically what that all means is that, like, hey, you did this and you received the data and you knew how you got the data. And so now, you've committed wire fraud in furtherance of a conspiracy to harm our business interests. And that's closely related to the second cause of action, which is conspiracy to violate RICO.
Okay.
Which basically means
you did it, but also you conspired to do it.
Yeah, Deel has violated 18 U.S.C. 1962d by conspiring and agreeing to violate 18 U.S.C. 1962c, as set out in forth in count 1 above, by knowingly agreeing to adopt the goal of further facilitating operations of the aforementioned enterprise. Enterprise in the sense of like the conspiracy.
Yeah, the organization of folks that are stealing.
So what the Does, so at the top of the complaint, you'll notice that it's they're suing, the defendants are Deel Inc., a Delaware corporation, and Does 1 through 100.
Yeah, I wasn't quite sure what that meant. I just kind of assumed that it meant we don't know who exactly these people are, and so we're just calling them Does. We don't know how many there are, so we're just saying 100.
That's exactly it, basically.
Sweet. Okay.
So it's called Doe pleading, and basically what you do is when you first file an action and you aren't sure who's involved, you do have to name specifically who you're targeting either in their personal or business capacity. And so what you'll do is you'll just throw up like Jane Doe, John Doe, 1 through 1000 or whatever. And then later as the discovery develops, you can amend your complaint to specify the parties involved.
Cool.
But basically you put your finger right on it. That's exactly what it means.
Glad to hear it.
I see a lot of news commentators getting this wrong. They're like, oh, yeah,
there's
a
100 people involved.
Exactly. And that's probably not the case.
Yeah, no.
The gentleman, what was his name? He was the spy?
Keith O'Brien.
Keith's in a load of trouble.
Classic Dublin name.
So now is a good time as we reach the third cause of action, misappropriation of trade secrets in violation of the Defend Trade Secrets Act, 18 U.S.C. 1836. Trade secret is different than a patent. So a trade secret means information, including but not limited to a formula, pattern, compilation, program, device, method, technique, or process that is both of the following. A, derives independent economic value, actual or potential. from not being generally known and not being readily attainable by proper means by a person able to obtain economic value from its disclosure or use, and B, is a subject of efforts that are reasonable under the circumstances to maintain its secrecy. This latter element distinguishes patent protection from trade secret protection. So basically, it's got to have some value and it's got to be not known to the public.
Got it.
Patents, which you may have also heard of, is basically the government gives you a monopoly in exchange for explaining everything about how it works publicly. So you file with the USPTO, the U.S. Patent and Trademark Office, usually like mechanical inventions, like you'll provide detailed schematics of mechanical inventions, and then if it's approved, you'll get a monopoly on sale of that specific thing for like 20 or 30 years. And so the idea is that patents are better when the mere appearance of your product on the market is apparent of how it works. So like drug companies, like they'll release a drug and then you could just get a pill and analyze it and get the formula and then reverse engineer it. So to prevent that and to protect their huge investment to make that drug, they patent it. Trade secrets are indefinite. So if, for example, your private marketing secrets, those are never apparent publicly. So you don't want to file a patent for them. This wouldn't even really apply for a patent in this instance. But like you wouldn't want to patent it because then you'd have to explain everything about it publicly in the attempt.
And that would make it all null and void anyways.
Yeah, exactly. Which is why patent attorneys are paid so much, because if you fuck up a patent filing and it's rejected, it's still on the public record. So that's why you make so much money as a patent attorney, and also why it's such a risky area of practice.
Interesting. I hadn't thought about that before.
So and we see in their complaint Rippling laying the groundwork for why these trade secrets are so valuable. Quote, Rippling has taken efforts reasonable under circumstances to maintain the secrecy of its sales and marketing trade secrets by allowing access to information only by Rippling employees and storing its sales and marketing trade secrets in a secure location only to Rippling personnel. In addition, as a condition of employment, Rippling requires all employees to sign CIPRA. Each employee's employment agreement requires such employees keep, inter alia, the sales and marketing trade secrets confidential. Employees receive and sign a global handbook that includes a code of conduct set forth expectations for employees' use of Rippling's confidential information. Basically, we've taken reasonable steps to keep this not public. There's tremendous value in like, hey, who we're talking to, how we pitch new clients. What our processes are like internally, our internal communications. That's all trade secrets. You should be made responsible to not like, what are you doing? Basically. I mean, there's more complicated ways to put it than that, but that's basically what it boils down to. They're laying out all the foundations to say the sales and marketing trade secrets are not generally known and available to the public. Paragraph 131, Rippling spent tremendous time, effort, and resources developing and cultivating the sales and marketing trade secrets. This seems like a very strong case to me.
It really does.
Yes.
Yeah, as someone with little to no legal experience, to me, this complaint and this suit seemed really, really well constructed. It seems like they left very, very few potential holes. They really spent their time covering all their bases. Yes. Would you agree?
Yeah, I would agree. And this sort of brings us to the fourth and fifth causes of action are basically speak directly to that. So fourth cause of action is misappropriation of trade secrets in violation of the California Uniform Trade Secrets Act, California Civil Code 3426. Supplemental jurisdiction. Here's a good time to talk about this. Ooh. This is a federal case.
Right.
What are they doing? What the hell are they doing, like, litigating?
Yeah, California. Oh, I hadn't thought of that. Yeah, wait, there's two of them, right?
Yes,
California
there's two.
Uniform Trade Secrets Act and the California Business and Professions Code.
Yep.
That's a good point. I hadn't thought about that.
Yep, exactly. So this is something called supplemental jurisdiction. So supplemental jurisdiction allows federal, not just federal courts, but here it's a federal court, allows the federal court to hear additional claims even if they lack independent subject matter jurisdiction over those claims, if they are related to a claim that the court does have original jurisdiction over. Oh. So there's a federal question and over, these are federal statutes, so they're in federal court. If a federal court has original jurisdiction over a claim based on diversity of citizenship or a federal matter in dispute, it can exercise supplemental jurisdiction over related claims. And this is what Rippling has asked of the court. Quote, this court has supplemental jurisdiction over Rippling's state law claims under 28 U.S.C. 1367 because Rippling's state law claims are so closely related to the federal claims that they form a part of the same case of controversy under Article 3 of the United States Constitution. Basically, non-complicated way to saying this is all related let's just litigate it all at once rather than having another case in California courts to retread all the same ground.
So this specifically allows the federal judge to rule on a state case here.
Yep.
Okay, cool. That's good to know.
I mean, in theory, I think the court could decline, but I think here the court is not likely to decline because it's all over the nexus of the same dispute.
Yeah.
It's the same facts.
Yeah.
Courts, federal and state, prefer to litigate in as few simultaneous places as possible. You'll see it sometimes, particularly when it's stuff like, oh, you pollute the river and then you give everyone in the next state over cancer. That can get kind of weird, but here it's pretty straightforward. I think the court is very likely to adopt jurisdiction over the California violations.
Makes good sense.
Fifth cause of action, tortious interference with a contract. This is pretty clever. Or not clever, but they were going to bring this up, but I think this is pretty cool. So, quote, Rippling has a valid and enforceable confidentiality agreement vis-a-vis CIPRA with DS. Deel knew or should have known DS's confidentiality agreement with Rippling. Deel willfully and intentionally interfered with this agreement without privilege to do so by aiding, abetting, and assisting DS in breaching his contract. Basically, we had a confidentiality agreement with our employee, and you induced him in ways direct and indirect to break that. So if you had a confidentiality agreement or any sort of contract, and I came along and said, I will give you $100,000 to break your agreement, we could get sued for that because we're deliberately, tortiously interfering in existing duly made contract and agreement.
Wow. So not only are they then the final count is against DS the spy himself, right? For violating his contract?
Yes and no. Sixth cause of action, aiding and abetting breach of fiduciary duty. As a manager, Rippling DS owed fiduciary duties to Rippling. On information and belief, Deel knew DS owed Rippling fiduciary duties. At all times alleged herein, Deel was aware of DS's conduct as alleged above, including that DS used his position at Rippling to steal confidential information to give Deel and provided Rippling employee contact information to Deel.
Okay, so they're persecuting Deel for inducing DS to break his contract, and they're persecuting DS for breach of fiduciary duty, but they're not persecuting DS for breach of contract.
Well, yes and no. A couple of things. Okay. DS is not a named party in this.
Oh yeah. Oh, I hadn't realized. I just kind of assumed that he fell into the dose.
No, this is all aimed at Deel only. So you interfered in the contract, and you aided, and relatedly, you aided our manager in breaching his fiduciary duty.
Okay.
So the goal of the complaint is to cast as wide a net as possible. So here, those are very closely related. They're kind of just throwing every allegation at the wall and to see what sticks.
Yeah, like spaghetti.
Yeah, exactly. And funnily enough, I just want to make sure this is correct. They go from the sixth cause of action to the eighth cause of action.
Oh, they accidentally skipped the seventh?
Yes. So on page, sixth cause of action on page 43, immediately followed by page 44, eighth cause of action. There is no seventh cause of action.
Looks like they're going to have to file a whoopsie motion.
No. Well, you can amend a complaint one time without leave of court.
Oh, good.
And this is a minor scrivener's error as far as I can tell.
Either they just accidentally called it number 8 or they forgot to include number 7.
Yeah. And the eighth cause of action is pretty self-explanatory here. Deel engaged in unfair competition on California Business and Professions Code 17200. Deel engaged in unfair competition, including unlawful, unfair, and fraudulent business activities. Deel's unlawful, unfair, and or fraudulent business activities included, but are not limited to, tortious interference with contract, aiding and abetting, breach of fiduciary duties, violating RICO, and violating 18 U.S.C. 1343 and 1836. Basically, it's the state statute for what we've already gone over. The court will likely to accept supplemental jurisdiction. They're throwing everything at the wall all at once.
Wow.
And their prayer for relief, wherefore Rippling respectfully requests that judgment be entered in favor and against Deel and Does 1 through 100, jointly and severally, including awarding compensatory damages in an amount to be determined at trial, the podcast where we cannot read our language. 2, awarding exemplary and or punitive or treble damages in the amount to be determined at trial. There's the treble damages from RICO charges. 3, awarding interest at maximum legal rate, all sums awarded. 4, awarding reasonable attorney's fees as permitted by law. 5, awarding all costs of suit herein. And 6, awarding such other and further relief as the court deems just and proper. And they also demand a jury trial. Plaintiff Rippling hereby demands a trial by jury to all issues so triable in this case.
So they're basically saying by way of this lawsuit, we want back all of the money that Deel supposedly would have taken from us with this espionage. Is that correct?
Well, they don't actually allege how much money that is.
Right. They're not actually stating that. They're saying it's up to the courts to figure out.
Well, so what they've done is you can't, generally speaking, a court cannot award something you did not ask for. So that's why they say awarding such other and further relief as the court deems just and proper. That's very standard common language you see in lawsuits at state and federal levels. I've seen commentators get this wrong. They're like, oh, such other and further relief. No, that's very common. That's nothing to be surprised about.
Just like an open-ended. If the court finds anything that we didn't list here, please.
Yeah.
Got it.
So I'm surprised that they didn't come up with a number out of their ass.
Yeah.
So a lot of what you'll see in these cases is they'll just make up a crazy number.
Yeah, $2 billion they lost us.
Yeah, and then in the news, that's how they get news attention. Files $5 billion lawsuit, and then that number always changes. It's foofy. It means nothing.
I see.
But here they don't actually allege, and I'm guessing that's probably because they don't know the full. Like, they know there's a spy, but they don't know the spy's full impact.
Yeah, and they wanted to get this lawsuit out of the door as quick as possible to minimize what Deel could do now that they know probably that their spy was discovered.
I guess I think what they want is discovery.
Yeah.
They want to dig through all of Deel leadership's phones. They want to dig through all of their systems, and then if they could put a number, that's when I think they'll start putting the screws to them. If I were Deel's leadership, I'd want to bury this lawsuit as quickly as possible.
Yeah.
I'd be running to. I actually maybe we'll see. I might be running to like beg. Well, but then again, I wouldn't have done this. So
yeah.
what do I know? I would be running to Rippling to just like beg them, like, please, we won't even file a response. What do you want? These are multi-billion-dollar companies, so we'll see who appears. I'm very interested to see how the response plays out. It's hard for me to opine on where this is going or the merits of the matter without getting Deel's side of the story.
Yeah.
But I think right now I really commend the team at Quinn Emanuel and Miss Messenger for how well they have laid out the foundations here.
Yeah, absolutely. And Deel, they have not responded to the lawsuit specifically, but their public-facing comment about this, quoting here, "Weeks after Rippling is accused of violating sanctions law in Russia and seeding falsehoods about Deel, Rippling is trying to shift the narrative with these sensationalized claims. We deny all legal wrongdoing and look forward to asserting our counterclaims."
No, okay.
So they're not just going to capitulate. They're going to fight this.
So they brought up counterclaims. So there's something called supplemental and compulsory counterclaims. So when someone sues you, there are compulsory counterclaims. If you do not countersue for damages related to the same dispute, you basically waive your right to recover that forever, generally speaking. It's a judicial economy. Basically, they want everyone litigating everything about this matter all at once while all the attorneys are in the room.
Yeah.
So as to not retread old ground later.
That would suck.
So if they don't bring counterclaims that are specifically compulsory to this nexus of facts, they would lose the right to pursue them altogether. So that doesn't surprise me. Supplemental counterclaims is when someone sues you, you can sue them back for literally anything. Like, if you sued me for breach of confidentiality, I could be like, well, you borrowed my lawnmower.
And you never gave it back, goddammit.
Exactly. So, and those do not require, those, if they're not related to the same nexus of facts, those can generally be brought within the statute of limitations, which is to say, as if no lawsuit had been filed at all.
Okay.
And the reason they permit this is judicial economy.
Yeah. Just make it as efficient as possible.
This is different than cross claims, where if you and I were sued by, I don't know, Hemmat Law, and it was for like being bad podcast hosts, and then during that, like the litigation, I could sue you. Could be like, this is actually your fault. It's a cross claim.
Lindsay made me worse.
Yeah, exactly, or something like that. So basically, there's all sorts of
messy.
Yeah. Ways that you can, like. You have defendants and plaintiffs like suing each other all the time for big, complicated. Specifically, the definition of a cross-claim. Cross-claim is a claim asserted between co-defendants or co-plaintiffs. That's a good call-out. In a case, and that's related to the subject of the original claim or counterclaim according to Black Law's dictionary. Again, judicial economy.
Okay.
But here, there's only one defendant,
one
plaintiff, so I don't think it's going to be a real
Yeah,
you know,
there's
factor.
not people to bounce counts around.
We should do another episode on the response.
Yeah,
that's gonna be a
let
lot
us
of
know
fun.
what you guys think of this story. And my favorite part about all of this is that this trap that Rippling set up is called a honeypot.
Yes.
Little fun fact for
Yes,
you.
it's a fantastic maneuver by Rippling's
Yeah,
legal counsel.
really a fantastic maneuver. I was impressed with their thoroughness and the fact that the hint, the bait to Deel was, we're talking shit about you.
Or our employees are.
Yeah. Just so you know, our people are talking shit about you. You should probably know about that.
And they stepped firmly down upon the rake of history.
I was telling someone about this story, and they were like, "They took that bait." Yeah, they took that bait.
See, it's again, every single week we realize how low the bar is.
Yep.
Lindsay, any final thoughts before we wrap up for the day?
Please, folks, do not take legal advice from a podcast.
Yeah, don't take legal advice from the podcast. This has been another episode of Gossip Without Prejudice. Everybody, please push all the buttons. Leave us a review. It's a huge help. Subscribe, follow, tell a friend. Go to gossipwithoutprejudice.com to submit stories, questions, feedback, thoughts, dreams, hopes, yearnings.
We'll read any and all of it.
Yes, pledge as low as $5 a month. We'll keep our lights on. We'd love to have you join our community. Again, gossipwithoutprejudice.com, and we will see you next week.
Thank you so much, everybody. Bye.